New reports show the family of Iryna Zarutska plans to file a civil lawsuit ahead of the one-year anniversary of her death this Saturday.
The 23-year-old Ukrainian refugee was stabbed to death on the Charlotte Light Rail in South End on August 22nd of last year. DeCarlos Brown Jr. is charged with murder in her death. Reports say the civil lawsuit would target external parties on alleged security and safety failures that led to her murder.
All right, it's time for another torts law class with Chief Legal Analyst Khalif Rhodes. Khalif, break this down here because it seems from what you've taught us, they would have standing to bring something against her in terms of a civil lawsuit. How do you see this going?
Yeah, I mean, I'd look at it from four different components. First, if you're attempting, you got to figure out who you're suing, and then so I would assume you're suing cats and any type of municipality connected to cats, right? And so it's do they have a duty to protect riders from third-party violent attacks? That's going to be the first question. Whether the attacks were reasonably foreseeable, that's going to be probably the hardest portion to prove. And then were the security failures that you're alleging that they failed to comply with or needed to have there, were they the proximate cause? But for your failures, would this injury not have occurred? This injury here obviously being death. And then if they are sued and it's a government entity, would they waive some future government immunity? So there's a number of hurdles that I will look at, but those foreseeability and proximate cause will probably be the two that make this the hardest case, hardest portion of the case when looking at it for sure.
CATS has pointed to the fact that they have increased some security measures, more police presence there, camera upgrades. All those are good things, but does that also kind of prove things weren't good a year ago?
I like the way you phrased that question. And so I tell you, like I tell a DWI person, a defendant, if I'm representing them, it's not about impairment, it's about relevant time of impairment. Like you can be impaired, just you can't be driving while impaired, right? So if you want to walk down the street and be impaired, totally different. In this scenario, it's the same way. If you're saying that you made these corrections yesterday, well, relevant time of the corrections, were they in place at the time that this occurred? And I'd look at the auditor's report. The auditor's report kind of helps the family and it hurts the family when you look at this lawsuit. They talk about that foreseeability, those gaps in security, fair enforcement. DeCarlos Brown didn't buy a ticket. All those types of things would say, hey, you had these issues at the time and they were reasonably foreseeable. But were the issues that you addressed, had they already been in the process of being fixed during that time, or did you start this after the stabbing? That will be telling in terms of the auditor's report won't be a smoking gun in terms of, okay, you're automatically now a liable city and cats, but it would be helpful to show, hey, these are the deficiencies that we're already alleging were there.
Who do you think's most on the hook here if those elements that you mentioned that were most likely? Is it cats? Is it the city?
It's probably cats. I mean, I would say if looking at the auditor's report, looking at it, because right now we don't have a complaint file, but I'm speculating based off how I would file this, that based off of my reading of the law, reading of the events that occurred, this is how I would form my argument going forward. And if I'm forming the argument, it's pointing directly at cats in terms of liability. You knew or were aware of these things. Your knowledge of that makes them reasonably foreseeable that you should have done things to protect this individual. And so for sure, I'm pointing to cats for the nearly what $470,000 or $2.3 million approximately that they were gave for safety and equipment that they weren't properly using. And so I can point to dollars, I can point to amounts that you guys were provided. There's a failure, there's gaps. That seems like accountability to me.
Khalif, sometimes when you talk about these things, you say, you know, it's better off to settle than try to open up a can of worms. But I feel like for cats, they've already pulled back the blanket because you've had the auditor's report. You've had so many people look into the lack of security there. So is this one of the things, look, we've already played all of our cards, so we don't mind going to trial.
Yeah, I mean, yes and no. I mean, trial that's the public policy aspect of it, where you want things like this to go away because they'll be bad for business, they'll diminish your brand and all that. But also litigation's expensive. And so you don't want to continue to go to trial for a case that you're ultimately going to lose. And if you can set a dollar amount on it and say, hey, I know I can sit down at the table and two sides can come together and come up with whatever dollar amount that we feel would adequately make us feel whole, right? Or we can put it in the hands of a jury and not know what that number is. That number could be significantly higher or it could be significantly lower. Based on these facts, if you put folks in the box and allow them to hear all the things that you failed to do, the number probably could be significantly higher. And then you start to look at the victims that were impacted by this, those victim impact statements, when they come into trial, when any of her family members would testify, that you would want to have an opportunity to sit down and control that narrative and control the dollar amount better than allowing someone else to do it.
All right, Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.